We begin with the escalating heat on defendant Donald Trump. The nation watched when he came to New York last week for that first criminal arraignment of his life. It was a trip that was a legal requirement, not a choice. Trump had to sit quietly in court for this unusually long arraignment, which included a rare rebuke from a judge for the violent threats that Trump had been publicly making. Those threats now the subject of a second civil case also filed this week by the DA dealing with the clash with some House Republicans. Well, here's the news right now. Today, Donald Trump is back in New York again, and again under court order. These are not trips that he chose. They have been forced on him by the law, and how often he is on, at least allegedly, under the allegations, the wrong side of the law. If you're trying to keep track, or it seems like this stuff is happening more and more lately, it is. If you're wondering whether this is normal, it isn't. The former president forced to sit and take questions under oath in the New York Attorney General probe of issues related to his criminal indictment. Well, that's a scene we have seen before. This footage is from a different date, but a case where he was also sworn in to testify under oath. This AG probe, where his last appearance came only after he was fined and held in civil contempt, where he then finally did show up for that deposition, and he did something he used to assail others for, although something that is his legal right. He pled the fifth, not once or twice, not on one tricky issue. He pled the fifth over 400 times. Now, A.G. James, in this case that he's sitting for today, alleges a money scheme, basically alleged fraud. And she's seeking $250 million in penalties, as well as other forced changes that they say will protect the citizens of New York and other people doing business honestly. They would seek, this hasn't happened yet, but seek a judgment to permanently bar both Donald Trump and his family colleagues from doing this kind of business in the state. The argument being that while in this other case he's not facing criminal punishment, the argument being that if he's convicted through this process, they have to protect others from this kind of habitual fraud. And that case, civil, is a smaller headache compared to the criminal prosecution that we have been covering. The DA there who indicted Trump is on offense. He's suing Trump's MAGA allies for interfering in the criminal prosecution. He's calling on a court to basically act to protect the independence of this open New York probe. Now, we've been reporting on this, how DA Bragg is basically using a more proactive and legally aggressive approach than the past prosecutors who have tangled with Donald Trump, who is an unusual defendant. I think even he would say so. Now, it appears the DA has learned something, maybe learned that where Mueller and Merrick Garland have tried to really play by the most traditional historic standards, and many people can discuss why that is sometimes advisable and very fair, he has learned that just doing things exactly the same way with this defendant may not be the best course of action. We've heard from some prosecutors, including last night on this program, that you do have to change gears sometimes and that the DA's aggressive approach is solid. And let me be clear with you. That doesn't mean the DA will win this case against Donald Trump. Only time and a jury can decide that. But it does mean that Donald Trump's typical plays, the things that he does so effectively to the great consternation of so many people, those plays may not work as well right now. We all know what he does. It's a defense that goes on offense. He uses public lies and pressure. Donald Trump sometimes will risk breaking new laws to duck accountability for past alleged crimes, and sometimes it seems like it's working, just like it worked at first when John Gotti tried to abuse the court system and threaten jurors. It worked until it didn't. Right now, I'm telling you, these plays may not be as effective. I mentioned Mueller. I have his very respected former deputy prosecutor leading that case, that probe of Donald Trump, on hand with me. But I'll tell you this. When you take it all together, when you look at, again, this not normal activity of Donald Trump making his second compelled trip to New York under court order this week in a related case, you have to remember, everyone said it's so unprecedented if we indict this former president. It's so unprecedented. What would we do? It's so unprecedented to do it when he's an active candidate. Of course, he declared earlier than most people to create that situation for people to wring their hands about what's unprecedented. So I will tell you this, because I always try to keep it real with you before I bring in our experts. You know what else is unprecedented? Having a sitting one-term president who had more aides indicted and convicted in one term than any other president in history. You know what else is unprecedented? Having someone now indicted and saying in public the reasons that he shouldn't go on trial is that he will summon death and destruction and violence against the very government that he once led. So you know what else would be unprecedented? To waver or back down during this relatively new, week-and-a-half-old test of our justice system. Let me bring in our esteemed experts tonight. One I just mentioned, the former prosecutor from the Mueller probe, the former FBI general counsel, the former head of the Enron task force, Andrew Weissmann. There are other titles I could mention, but we only have so much time, Andrew.
Yes, let's get to it.
And Danny Greenberg, who is a longtime and decorated defense lawyer. He's the co-founder of the advocacy group Experience Justice. When you look at that criminal arraignment room, Danny, you know your way around that. You've actually been someone who's overseen the lawyers who defend people with less resources than Donald Trump, indigent defendants in that room, right?
Yeah, not one of whom paid off a porn star.
So there we go. We could start there. I should mention, in full disclosure, you're here for your legal acumen, but you are a family friend as well, and I like everyone to know everything. They can factor that in if it seems like I'm being nice to you or treating you too informally, like we're at the Seder table.
Whatever it does.
Whatever it does, it's in.
Fine with me.
It's transparently disclosed. Andrew, I laid out some of what we learned and why it matters that he's back under court order today. What do you think?
So I think the reporting, which is that although Donald Trump, the first time around, as you said, took the fifth over 400 times, the reporting is that he actually is answering questions. And the issue is that a good thing or a bad thing? Mm-hmm. So, you know, in thinking about it from his perspective, there are a lot of pluses in terms of his trying to answer questions and not assert the Fifth Amendment. One is he can try and get around an adverse inference, because if he leaves the record as it is, Letitia James has the underlying proof and his assertion of the Fifth Amendment. And that's what the jury will be told. And that makes her case really easy. So,
because in this kind of case, they can say to the jury, yes, that's a right, but it's bad that he wouldn't just answer why the numbers don't add up in this alleged fraud.
Exactly, because it's a civil case.
Yep.
A criminal case, you'd be thrown out if you ever tried to do something like that. Second, he has a better chance of knowing what to shoot at, because when he first took the fifth, Letitia James hadn't brought her case yet. So now he has a really detailed complaint. I mean, it is voluminous, so he can look at it and say, OK, I know where to puddle jump. I know where the weaknesses are. I know where I can say something and I may not get in trouble. Those are all pluses. I'd say another potential plus is that he's unlikely to be saying anything related to the Mar-a-Lago criminal investigation or the January 6th criminal investigation. And you can tell there's a big but coming here. And the but is that, by all accounts, the current DA, Alvin Bragg, has said he still has open his criminal financial investigation. Mm-hmm. In other words, the criminal component to what Letitia James did. Mm-hmm. If Donald Trump says something that is anyway false and Alvin Bragg can prove it, his case gets much, much stronger. And many defendants go down because they have a lot of hubris and they can think, OK, I can sort of like BS my way through this. And if you get caught with one or two false statements that the DA can prove, that case gets much, much stronger.
Have you ever sent arrogant people to jail?
Well, you know, I used to prosecute basically a bunch of rich white executives, and many of them, almost because of the nature of their work, are sort of type A, people who sort of feel like they can control everything. And that is a really hard client to have, as Danny knows. When you are a defense lawyer, you really need to be able to control those people and rein them in from their worst impulses. So here, that is going to be the issue. There's like pluses, and there's one really dangerous third rail, which is, is he going to say something that the DA can show is false? And because of his hubris, he thinks he's not going to get caught.
It's really striking. I haven't heard anyone quite flesh out what that criminal exposure is today. And there's so much going on that I'm not sure if this has gotten as much attention. So that's really striking. Danny, before I get to the harder question for you, which is what you offer for Trump's defense in this kind of case, I did mention that arraignment room, your lawyers know it well.
Oh, yeah.
I'm just curious what you thought seeing not only a former president in general indicted, but specifically in that room. I worked very briefly at Public Defenders. You ran legal aid for years. What did you think?
Well, it's interesting. One of my favorite stories about arraignments was a friend who was a clinical teacher. And one day he was showing some Japanese lawyers around, and it was night court. And after about an hour, one of the lawyers came up to him and asked him, "Where's the other part that's open?" And he said, "There is no other part. At night, it's just one part." The lawyer came back about a half an hour later and said, "I don't understand." And so my friend said to him, "Why are you asking me the question?" He said, "I want to know where the white people are arraigned." He had sat there for an hour and a half in night court and had not seen one white person arraigned in Manhattan criminal court. So when I hear people talking about how unusual it is that a former president is arraigned, the real thing is how unusual it is that anybody is arraigned who isn't somebody who's been a victim of stop and frisk and the rest of it.
Yeah.
I hear about how unusual it is. Will we really have an ability to prove the felony? You've gone into this so well, and Andrew has as well. The misdemeanor being a state court, the felony makes it a thing. A DA overcharging someone? Are we shocked about this?
Right.
The DA always does. He overcharges because he wants a plea. He overcharges because he wants the jury to come back with a verdict that's a compromise. Okay? So on one hand, I look at this, and of course I recognize how unusual it is. But a part of me just says, this is business as usual.